ladies and gentlemen. It's my honor and pleasure to welcome at Vilnius University Faculty of Law the representative of one of our best friends in Poland, in Polish University, Krakow University, Jagiellonian University, Martin Wójcik, who is was student at the time when we have a very close connection and collaboration with the Jagiellonian University Faculty of Law and Department Chair of Labor Law. And he was a student at that time, and for me especially it's very nice and I appreciate really that from the student time we have now a very strong Polish colleague, academician, working very actively at University of Krakow, doing academic work, but also being responsible already in this young age, a responsible expert in Social Rights Committee, which is created under the framework of European Social Charter. And his expertise and his academic work will be of best value and should be used by you during this lecture. And I'm very glad that you came here. And Marcin, thank you very much for coming, and I wish the best success not only today in this classroom, but also in your career and in your scientific work. Thank you very much for coming.
Thank you very much. Just what I would like to say, thank you for hosting me to you, Professor Dalboulis, and to Professor Petrolaite. As Professor Dalboulis said, I was first here as a student, and now I am an academic teacher, so they are partly a father and mother of gaining a degree by me. So thank you very much for your kindness and all of help. And
all the success.
I'm John related.
And most of you I'll see at 1 o'clock in my lecture.
So now we are going to coffee. I have some material printed for you. This is a European Revised Charter. Maybe firstly I will allow myself to sit, it will be easier. First of all, a little bit about me. I am assistant professor at the Jagiellonian University. This is my third time in Vilnius. Truly speaking, the weather is the worst from all these three times, but nevertheless, it is still very pleasant to be here. As Professor Dalboulis said, I am also a member of the European Committee of Social Rights, and my two lectures today will focus on this international body. The lecture will consist of three main parts. During the first part, it will be the first hour. I hope maybe it will be shorter, depends if you will look like interested or not, will be about the Council of Europe and about the committee. The second one will be about the European standards of European Social Charter regarding social rights and labor rights. And at the very end, I also have some conclusions from the committee regarding Lithuania, because as I will say, but I just remark you this, committee is responsible for evaluating if particular member country fulfill the obligations of the charter. And also Lithuania is a member. There were some non-conformities about Lithuania. I will try to present you two articles and tell you why committee decided that there are some non-conformities with the provision of the charter. But firstly, and allow me, I will support myself a little bit about about my notes, I will tell you about Council of Europe, and of course please feel free to ask any questions if something will be not understandable or you have had some emerge questions. Please just notify me, and of course in the very end I also have some time to ask for your questions or after the classes or part of the lecture. Starting from the very beginning, the Council of Europe is one of the oldest or even the oldest regional organization established after the Second World War. And the aim of the Council of Europe is promoting cooperation between European member states in the following areas. So it is human rights, democratic development, the rule of law, legal standard, and culture, common efforts. There are 47 members of Council of Europe. One of such members is Lithuania as well. What is important, because it is very often mixed or confused, the Council of Europe, and I suppose you know that, it is in the European Union. So these are two different international bodies. And the head office of the Council of Europe is Strasbourg, so very often, and also the Committee of Social Rights has its head office in Strasbourg. Very often when I go there to the session of the committee, people ask me, okay, so how was it Brussels? And I every time have to explain it is not the Brussels, it is Strasbourg, it's not the European Union, it's the Council of Europe. But I suppose that you exactly know. The Council of Europe was founded on May the 5th, 1949 in London, and the states which signed the treaty was Belgium, Denmark, France, Ireland, Italy, Luxembourg, the Netherlands, Norway, Sweden, and the United Kingdom. And maybe a little bit about the structure of Council of Europe. So the most important body is the Committee of Ministers. So this is the body which consists of the person delegated by the governments of the member states. Another body is the Parliamentary Assembly, and there are representatives of the parliamentary of the member states. So each parliamentary assembly of particular member states should delegate their representatives to the Parliamentary Assembly of Council of Europe. There are also some. Do you know which is the famous body of the Council of Europe? The judicial body. You know, but you don't want to tell me yet. So this is the European Court of Human Rights. The European Court of Human Rights is the permanent judicial institution which guarantees for all Europeans the right to safeguard. And probably it is the most famous because of those rulings. So you probably heard of many rulings of this body. Another institution which are created within the Council of Europe is the Congress of Local and Regional Authorities. The Commission for Human Rights, this is the person who fights for rights of individuals. And for example, also the Conference of International Non-Governmental Organizations, so-called NGOs. According to the statute of the Council of Europe, the aim of this body is to achieve a greater unity between its members for the purpose of safeguarding and realizing the ideas and principles which are their common heritage and facilitating their economic and social progress. And one of the body which is devoted to realize this aim is European Committee of Social Rights. In a moment I will tell you, but firstly I want also to say a little bit about the symbol of Council of Europe. It is very similar like the symbol of European Union, so it is a European flag, and there is 12 stars, gold stars on this flag. And why? And here's the explanation. Against the background of the blue sky, the stars form a circle symbolizing union. The number of stars is fixed, 12. It's not because there is a 12 creating countries, but it is a symbol of perfection and completeness, and bringing to mind the apostles, the sons of Jacob, the labors of Hercules, and the month of year. And sometimes it's also added that this is a symbol of a clock, but well, it is not the founding idea which was created by the fathers of the Council of Europe. Now a little bit about Committee and European Social Charter. First was the European Social Charter. Generally there are two charters. In front of you you have revised European Social Charter. So this is the second agreement which was signed. But from the very beginning it was the so-called the European, not the revised, but the simple European Social Charter. It was signed in 1961. And it is a fundamental international treaty in which labor rights are regulated by labor and social security laws. I will tell a little bit later about the rights which are guaranteed by the Charter, but for example it is the right to work, the right to just condition of work, the right to vacational trading, in the area of labor law, the right of workers to create trade unions or to go into collective actions. In 1996, the revised European Social Charter was signed, and well, this charter repeats a lot of rights, but also which was put in the first charter, but also adds some news, which is a little bit broader. What is also important is that European Social Charter created a special supervisory body. From the very beginning it was called the Committee of Independent Experts. Then the name was changed, now it's called the European Committee of Social Rights. I am a member of this committee. The headquarters of this committee, as I said, is in Strasbourg. The committee usually meets 7 or 8 times a year. And the committee performs 3 basic functions. First of all, it establishes European standards in terms of labor law, social security and social policy. So this is the first main task. Secondly, it examines the reports delivered by the authorities of the member states and declares compliance or non-compliance, so conformity or non-conformity of the national regulations with the standards created by the Charter. And I will also describe a little bit this procedure. Generally, each country has to submit a special report, and the committee decides if the regulations within the particular country breach the Charter or not. And the third main task of the committee is recognizing collective complaints registered by international workers and employers. And this is the task which is more and more important and popular, and this results in changing the role of committee from the supervisory body to the quasi-judicial body. And I will tell a little bit more also about that. As I said, the committee sits on plenary session in 2 working groups, so there are 2 subcommittees. I am subcommittee where it's using English and French, and the second subcommittee, number 1, basis only on the English language. And it wasn't such this way from the very beginning. the decision to divide into two subcommittees was made because it was too much work. So the committee had to divide into two groups which work parallelly, and there are general sessions when everybody are present, and also there are sessions in subcommittees. Generally it is because the session lasts approximately 5 days, 2 days of general sessions and 3 days in subcommittees. The work of the committee is managed and administered by the board, consisting of a chairman, the two vice chairmen, the general rapporteur and the secretary executive. So there are 15 members, but we have our president, this is a colleague from Spain, two vice presidents, this is Professor Schlachter from Germany, and Professor Stangos from Greece. And also there's a general rapporteur, which is an Irishman, very nice guy, and the general rapporteur is responsible for keeping a consistency of all our decisions. So this is the worst work because he has to read everything and analyze if there are no contradictories with the previous decision and previous documents. And he's also an Irishman, so he makes also proofreading because his English is very well. And starting from the first aim of the committee, the rules of the conduct for the committee, so there's a special regulations how the committee should work, states that the member states are obliged to deliver reports of two kinds. Under Article 21, they are obliged to provide reports about the ratified provision of the charter, so the provision which they accepted, and they have to say how they realizing this provision. And under Article 22, about the provision of the charter that have not been ratified. So they not only has to present how they are aiming to realize what they ratified, but also what is the state in the regard of the provision which they decided not to ratify. The authorities of the member states are obliged to present to the Secretary General of the Council of Europe the reports from the enforcement of the provision of the Charter once every 2 years. And then the Secretary General forwards these reports to the committee, which performs a content-related examination. So the procedure is that each country has to prepare a special report, and there is a special form with, I'm not sure, but it has about 15 pages and something like 100, 150 questions, and the country has to give answer for each question. And because there was many work, many questions and many materials to evaluate, the committee decided to divide countries into groups, and also the provisions on into groups. In 2006, it was decided that provisions of the Charter have been divided into 4 thematic groups. 2 of them deal with labor rights, and the group, this first group is called Employment, Training and Equal Opportunities. The third group is labor rights, and some provisions related to labor rights are included in group number 2. It's called Health, Social Security and Social Protection. And there's also a fourth group, and it consists, for example, articles regarding protection of maternity, equal opportunities and equal treatment. What I didn't say, and maybe I should mention at the very beginning, but the social charter covers not only the labor rights but also social rights, for example, social assistance. So it is very broad then, different rights are evaluated under the Charter. For example, there was lastly a collective complaint regarding the abortion. So it is not strictly linked with the labor rights, but the committee also evaluated if access to the abortion or to the right to have it is possible under is required under the Charter or not. The dates of delivering the report is 31st of October. So every country should submit its reports till this date, and well, very often countries are delayed and ask for the prolongation. Because there are 4 groups, every provision is analyzed by the committee every 4 years. So each country has to submit report on one group for 1 year. The next year it has to deliver a report regarding the second group and so on and so on. The Committee of Ministers regulates the form of the reports, so it is what I say. The reports are presented in one of the 2 official languages of the Council of Europe. It is in English or in French. The reports are usually exhaustive studies with the attached provisions written in the language of the state delivering the report. The authorities of the member states can present copies of summaries of the reports to the International Labour Organization. So I suppose that you exactly know also that the most important body within the labor rights and employment rights is the International Labour Organization, in the seats on with a headquarters in Geneva, and also under the regulations of ILO, the countries are obliged to present the reports to the, especially to the Committee of the Freedom of Association. And very often countries decide to attach to the report to the Council of Europe the report which they prepare for ILO. Now it is sometimes easier, they have some data, we just refer answering for our question to the report, and it is easier for them. And for the committee it is additional source of information. The lack of a delivery of the both data justifies the delay in making a ruling upon the compliance or non-compliance of the national regulation and practice with the international standards. The committee has elaborated the practice of warning a member states when it does not deliver the required information for the second time. So as I said, sometimes countries just do not answer to the questions. It is because they do not understand that, or they just do not want to understand. So they say, okay, we are writing something, but committees, the members of the committee read this and say, okay, but there's no answer here. And then the committee gives in his conclusions the warning. So if you do not deliver next time, so in 4 years, because the cycle is 4 years, the data, then we decide that there is inconformity because of the lack of information, not answering for our question. And as I said, the first reports regards ratified provision, and the reporting procedure ends with the conclusions. And I will present you in the very end of our meeting today such conclusion. In this conclusion, committee says, okay, so we see that everything is in conformity, or we ask for additional information because we don't have enough knowledge to say if it is compliance or non-compliance. And we are giving you warning. If you do not provide this information, then we will decide that it's in conformity. And the third option is saying that there is inconformity, and always committee indicates on what grounds. So, for example, there is too big rate of unemployment, or there is not enough support from the social assistance bodies within the countries. In the doctrine, there is a dispute if the rulings of the committee are binding or not binding character. So if the countries should fulfill it or not. And well, from my perspective, they are binding character. So if somebody has decided to ratify the treaty and say, okay, we ratify it because we want to fulfill these standards, then the country is obliged to fulfill the standards. But there is, truly speaking, no real mechanism of enforcing these standards. So the committee may say, okay, you do not fulfill the standards, there is inconformity, but the most touching or striking results for a country is just the public aspect. So that there is some message from the media, this country breaks the European standards. But well, there is no real way of putting these conclusions into force. Of course, they can be eliminated from the Council of Europe, but well, I do not suppose that there is a chance to do it because there are not so big breach to use so much, so harsh way of making them function. So, concluding that part, we may say that these are binding decisions, but without any real power to enforce them. So, lex imperfecta, let's say. And the second way of reporting is reporting provision of a charter that have not been ratified. The Committee of Ministers have a right, so this is the most important body, have the right to request the authorities of the member state to deliver the reports concerning the relationship between the national regulations and the practice of their applications and provisions of the charter. And this mechanism wasn't used from the very beginning, but nowadays it is very popular. Next year, I think it will be 6 or 5 countries asked to deliver such report. And of course, such reports is very often followed by the visiting these countries. There are special meetings with the authorities of the particular country, and this report on non-ratified provision are discussed. And what is the aim? Well, the aim is to encourage countries to ratify the provisions, to present them advantages of ratifying. And of course, very often it is a very long way, a long procedure. For example, I know that in Russia, meetings are every year, and they haven't ratified any provision for more than 6 or 5, 7 years. The same situation is in Poland. Poland refused to meet because they are afraid of being pressured by the committee. But for example, Czech Republic ratified lately the revised social charter. So such meeting sometimes have a result, but very often it is just the way of making very small steps. Another important body of the European, of the Council of Europe, which is important for the Committee of Social Rights, is the Governmental Committee. And the Governmental Committee consists of the representatives of the governance of a particular country, and The aim of this committee is to prepare the decision of the Committee of Ministers. So they receive conclusions of our committee, Committee of Social Rights, and they discuss them what should be the decision of the Committee of Ministers. And the Government Committee is obliged to perform the selection of the case, which should be referred to in the recommendation issued by the Committee of Ministers addressed to the Member States not abiding by the provision of the Charter. In a moment I will say what is a recommendation. It is a way how the Committee of Ministers tries to convince country to oblige the standards of the Charter. Presenting the case of non-compliance of the provision of the Charter by the Member State, the Governmental Committee chooses in a well-grounded way the base of the examination concerning social and economical policies, situation which, according to its opinion, should be commended within the recommendation addressed to the interested party, a Member State, according to one of the provisions of the Council of Europe. And for a long period of time, there was a contrasting difference between the Governmental Committee and the Committee of the Social Rights. We may say that it was a fight between these two bodies. As early as during the first supervisory cycle, it declared the Governmental Committee, the lack of enforcement of a significant number of provisions in case of the majority of the Member States that delivered the reports, as well as postpone the decision due to the missing information. And then the Governmental Committee reacted. The Governmental Committee accused our committee, and that time it was called the Committee of Independent Experts, of two rigorous interpretations of the provisions of the Charter and produced its independent interpretation. So the Governmental Committee said, okay, so you are too harsh on the countries. You should be more liberal. You shouldn't give so many in-conformity decisions. The rivalry between the said committees was caused by the unclear division of their competences, and from the first to the 11th supervisory cycle, the report of the Member States were evaluated differently by the said committee, as the Governmental Committee claimed it had the right to make content-related evaluation of the reports previously evaluated by the Committee of Independent Experts. So simply they just changed decision of the committee. They say, okay, you were mistaken here, there is no breach of the European standard, everything is okay. But then the regulations of conduct of the committee were changed, and nowadays only the Committee of Social Rights has right to make content-related evaluations, and the Governmental Committee can't change its decision. After the Governmental Committee go through these conclusions, they are passed to the Committee of Ministers, and this body adopts by a 2/3 qualified majority of votes of the representatives of the states parties to the Charter a resolution concerning the whole supervisory cycle, as well as individual recommendation addressed to a particular Member State. The basis for the resolution passed by the Committee of Ministers is the report of the Governmental Committee, and the Charter does not specify any guidelines for the Committee in terms of adopting resolution and or recommendations. The resolution is general, they concerning all rights, all decisions of the committee, especially about elaborating of its standards. And the recommendation is addressed to the particular country and say, okay, you don't fulfill this provision, you should make something work better, you should increase the level of protection of the standards. And after this procedure is ready, the conclusions are published. Generally, it was always due in Strasbourg. This year, for the first time, we went especially to Brussels, to grab a public attention. So there was a special conference, there was a lot of reporters, and the conclusions were presented. Well, the conclusion is something like this, because there are many countries. This year there was, I do not recall exactly, I'll tell you in a moment. 1, 2, 3, 4, 5, 6, 7 articles were evaluated, but of course each article has paragraphs, and some of these articles have 6 paragraphs. So this is a pretty exhaustive material, but nevertheless the general information was given. Of course there was questions about particular countries, and after that, for example, I saw it on the Polish media. There was information that the European Committee decided that Poland breached the European standards because there are too long queues. And of course it is correct, but well, how the media presented is much worse than it was presented in conclusion. And as I said, this is the most important results of the conclusion, to exert media pressure of the countries. Yeah, the society sees that there are some aspects to improve. And this is the first procedure which is conducted by the committee. And this is the part which nowadays takes the most time of the committee. But it has changed a little bit for 4 or 5 years, because there was created a second function of the committee, and it is a collective complaining procedure. And this becoming more and more popular. Not many countries already ratified the additional protocol which regulates this collective complaint procedure, but there are, I would say, some progress in it. So every year, every 2 years, some new countries ratify this this additional protocol, and then thanks to that, it is possible to implement a collective complaint procedure regarding these countries. But beginning from the very beginning, this collective complaint procedure was introduced by the additional protocol from 1995, and this protocol gave the committee the status of a quasi-judicial body, so not the very same as European Court of Human Rights, but also having some judicial power. The committee was vested with the power of examine collective complaints lodged by selected international and national organizations against the authorities of the member states violating the provisions of the European Social Charter or the revised European Social Charter, which do not adapt their domestic labor and social insurance legislation to the European standards. Under the additional protocol, there are only, I don't know, few, but there are 4 or 5 categories of the organization which have right to lodge a complaint. And the first are international employers organizations and trade unions invited by the subcommittee of the governmental committee. So within the governmental committee, there's a possibility for some international trade unions to participate. As a member of this governmental committee, they give in their opinion. And nowadays, there's only one international trade union organization, which is the European Trade Union Confederations, so-called ETUC. I don't know if you're familiar with it. This is the biggest European trade union organization. and two international employers associations, which is the Union of the Confederations of Industry and Employers of Europe, and the second one is International Organization of Employers. So this is the first group. This body may lodge the complaint. The second group are other international non-governmental organizations having a consultative status with the Council of Europe and placed on a list established for the purpose by the governmental committee. So, almost each NGO may apply to the special list which are conducted by the governmental committee. And there is every year a special time for uplink, for application. And after that, there are some not very demanding requirements. If they are signed to this list, they gain rights to lodge a complaint. The third group are national employers' representative organizations and trade unions, but they have the right to act only within the jurisdiction of the member state of the Council of Europe. So these two previous groups, they may lodge a complaint against any of the member states. The organization within this third group, they have right to lodge a complaint only against their own country. So if they act in Lithuanian, they can lodge a complaint only against Lithuanian. In Poland, only against Poland. And there is also the fourth group, and it is representative national non-governmental organization, and they are entitled to carry out their statutory activities within the jurisdiction of the member state of Council of Europe, against which the complaint is made. So these NGOs, first of all, have to be representative. And well, this is very vague term. There is no clear explanation what does it mean representative. Generally, the committee says that if they act within on the territory of all country, they are representative and do not analyze if they have 100 members or 2 members. It is important if they cover all country. And secondly, they may lodge a complaint only within their statutory activity. So a committee analyzes if they have in their statute, in their statutory acts, information that their aim is to do something. And if it is related to the complaint, there is decision of admissibility. And decision of the admissibility is the first steps, or maybe second step, because first step is to lodge a complaint. It's the first step made by the committee. So there is analysis if this organization which lodged a complaint have a right to do this. And truly speaking, out of 101 collective complaints made to the committee in the years 1998 to the current time, only one was lodged by the Organization of Employers, which is interesting, 51 by NGOs, and 41 by trade unions and trade union organizations. During the pre-court proceedings on this decision on admissibility, I have to take a seat because I have problems with speaking, sorry for that. During the pre-court proceeding, the committee examined the right of the International Lawyers Association to lodge a collective complaint against the authorities of Portugal to allow employers to employ children less than 50 years of age, which constitutes a violation of Article 7 of the Charter. Another example is that the committee also had to decide whether a Quakers organization has the right to lodge a complaint against Greece, which violated the provision prohibiting forced labor. After this decision on admissibility, there is a second step, and this is the content-related analysis. A collective complaint can only be made in the event of alleged unsatisfactory application of the European Social Charter by the authorities of the member state. So, I suppose it is quite obvious that in the complaint, the complainant can argue that there is a breach of some general rights. It has to be related with the charter and indicate that there is a breach of particular provision of the charter. The allegation made in a collective complaint should be general in their nature. They ought to refer to a specific case of an unsatisfactory application by a member state of a particular provision of the European Social Charter, or non-compliance with a particular European standard laid down by the Committee on the basis of the Charter. And, for example, the Committee of Ministers of the Council of Europe, in the above cited decision, ruled out a possibility to admit complaints concerning individual cases where the state authorities or state administration violate any social or economic right included in the European Social Charter. So, the complaint should be in general nature. So it couldn't be lodged in the name on behalf of the individuals. There always has to be a breach of the standard concerning more than one person. So it has to be discriminated. All group, some rights of all group has to be breached, not individual person. The analysis of 101 collective complaints examined by the committee shows that 39 collective complaints are concerned with unsatisfactory applications of the following provision of the European Social Charter by member states. It is ban of child labor. This is very often because there is very active French organizations which fighting for rights for children, the right to organize, the right to bargain collectively, the right to strike, as well non-discrimination with regards to the right to work and a prohibition of forced labor, the right to vocational training, once again this French organization fighting for children, the right to just condition of work, the right to work in safe conditions, the right to fair remunerations, and, for example, the right to information and consultation. So this is very often the rights which are under analysis of the committee. Formally, the collective complaints are addressed to the Secretary General of the Council of Europe, so I would say the Prime Minister of the Council of Europe. The additional protocol, which regulates the collective complaint procedure, requires the Secretary General to acknowledge the receipt of the complaint, to notify the member state concerned of this fact, and to immediately forward the complaint to the committee. So the member is notified that there is a complaint. They are asked to give a response, and the complaint is forwarded to the committee, and then the president decides which member will be a rapporteur of this complaint. So every member of the committee is responsible for one or more collective complaint, and he conduct the procedure and present the result of this procedure to the whole committee, because it is always the decision of the committee if the complaint will be admissible and if they decide if there is a breach of law or not. A collective complaint should be made in writing in one of the two official languages of the Council of Europe and signed by a person authorized to represent the entities entitled to lodge collective complaints. So this is the formal requirements. There are no balance to lodge a complaint similar to the balance which are in the, I suppose, also in the Lithuanian procedural, civil procedural law, because the fact that the case is pending before other authorities, for example, before the European Court of Human Rights or before the Committee of Freedom of Associations of ILO, does not preclude, does not make it impossible to lodge a complaint to the committee. So there is no res judicata. There is no time limit, the lapse of which, in the case of individual complaints, result in the loss of right to demand certain benefits. So it can be lodged even after 5 years, 6 years, 10 years. A collective complaint can be lodged even if not all available forms of legal action before domestic state authorities against which the complaint is lodged have been exhausted. Do you have a tribunal court, constitutional court? Yeah, and Supreme Court, yes, so I suppose it's the same as in Poland. So, for example, to lodge a complaint in Poland to Constitutional Court, it is required to use all procedural steps. So first the Court of First Instance, then appeal, then the Supreme Court. And sometimes also to go to the Ombudsman. And if the person does not fulfill this following step, then there is no right to go to the tribunal. And in case of the committee, there is not such requirements. So even if we stop at the very beginning, do not appellate from the decision of the court of the first instance, we can lodge a complaint to the committee. The cases of the violation of the right to organize are dealt with the ILO Committee of Freedom Associations and by the Committee of the Council of Europe. So this is what I have already told you. There are two committees and they are very often supporting themselves. We have a Russian colleague, professor from Moscow University, and she's a member of two committees. Our European Committee of Social Rights as well as this committee of ILO. And as I said, making a complaint in one of these institutions does not exclude the possibility to refer to legal opinion on domestic legislation concerning collective labor law and common practice. What is quite important is that the committee may examine a collective complaint during a trial. So generally, the evaluation of the complaints are not public. So nobody besides the member of the committee and besides the secretariat of the Department on Social Charter are allowed to be present during such session. I will make a quick reference to this secretariat. Well, it is a little bit of secret, it is not so often said, but I will share with you with this because, of course, members of the committee are not able to deal with all cases, to prepare all decisions, especially conclusions. So they are always supported by the secretariat. There are special persons dedicated to the collective complaint procedure and to the reporting procedure, and they prepare drafts of the decisions, and then the committee members is analyzing and implementing changes. But well, the most of the work is done by the members of the secretariat. So they are employed by the Council of Europe and they prepare drafts, of course, under the supervisory of the committee members, but nevertheless, well, this is quite helpful because there is a decision written and we just have to indicate, okay, it is all wrong, change it, or okay, it is, we approve it. So this is a role of secretariat and this is quite important. But sometimes the session, the examination of the collective complaints can be open and can be done by going into trial. So this is why the committee becomes very similar as a European Court of Human Rights, because we also have possibility to have a trial. And during such trial, the parties may participate, and the committee makes the decision on the form of examination during a plenary session. The committee decides to proceed with the participation of the parties before expressing the conclusions, whenever it believes that such procedure is necessary. And of course, once again, it is a very vague term, but as lawyers, you probably know that sometimes such vague terms are required to cover all possible situations. And such trials are held, they are open to public, as I said, are held in Courtroom of the European Tribunal of Human Rights. The parties and the representatives put forward their arguments and offer additional explanation. And there's also the right to present opinion by the organization which have a status of amici curiae. So, any organization who has a right to be a complainer may also decide to participate during such trial as an amici curiae and present their opinion. Okay, let's say that in our opinion this should be done, there is a breach, there is no breach, and so on. The proceedings of the committee are concluded with a report stating the findings of the committee and the ruling concerning the collective complaints. The report of the committee is presented to the Committee of Ministers of Council of Europe and to the parties. On the basis of the findings and the rapporteur of the committee, the Committee of Ministers, so one again, this is the most important body of the Council of Europe, passes a resolution or a recommendation. So once again, these two kinds of acts. A resolution stating the compliance of domestic legislation within the European Street Charter or the revised European Street Charter. So the resolution says that everything is okay. And a recommendations is stating unsatisfactory applications of one of the two charters requires a qualified, and it requires qualified majority of 2/3 of votes voting. And coming slowly to the end of this part, truly speaking, I need a break. I hope that you agree for that. Coming to the conclusions, as I said, it is a problematic if the committee is a judicial body. But what is important is that it does not deal with any individual complaints concerning instance of violation of the provision of the European Social Charter by the member states. With regards to collective complaints, the committee does not adjudicate. It gathers information and adopts a stand whenever an entitled entity lodges a complaint against a member state. And the procedure followed for the examinations of collecting complaints, as presented above, shows the committee follows the path of international bodies of justice competent to examine complaints in matters governed by the labor and social security legislation. So that's why we may say about the committee as a quasi-judicial body, because year after year, this collective complaint procedures becomes more popular, more important, and there is, I don't know, definitely a chance, but also a position and approach within the committee that committee should be more focused on the collective complaint procedure than on the reporting procedure. So. Probably because it has more influence, it deals with the more hectic and more important cases, which are important for the related organizations. And for the very end of this part, I don't know, fortunately or unfortunately. There is also such institution according to the regulations of conduct of the committee to implement immediate measures. And so probably once again, comparing to the national procedure, there is something like that in your own civil procedure, that if we have some claims, we want to secure them. For example, the court bound to sell a property, because if we sell, then we won't be able to get our money. And in case of committee, such immediate measures are aimed to prohibit from breaching a right, some standard which is constituted in the charter. These immediate measures were introduced in the regulations three years ago, and very often the complainants ask to use these immediate measures, but it's very difficult to do it. Lately, one complainer asked us to make a country to change a law, because they claim that there's a law, this law breaches a standard of the charter, and they ask, before you adopt your decision on this complaint, please introduce immediate measures and make the country to change the law until the decision is made. So, well, for the committee, it's very difficult to take such position, because we don't have right to say, okay, you have to change the law. No court say that you have to change the law. They only say, okay, the law breaching some principles. So in this case, we refuse to impose such immediate measures. But there is another very promising case, and it was introduced by the Holland organizations. They claimed that there is a breach of the right to housing. That there is a lot of persons who does not have accommodations, and that the country does not provide any shelters for them. And that there is a risk of life for them, because it was cold outside and they didn't have any chance to find a shelter. And such immediate measure were introduced. Committee asked the country to protect these people. And after this decision, the country decided to find a place for all, and I suppose it was in Amsterdam, for all homeless person who was on the street. So in this case, immediate measures resulted in very good way, and well, it shows that sometimes it's good to ask for such immediate measures, and they really can help people. Okay, so I think that the 1 hour has passed, and now we are starting at 11. Yes, the next. I don't know if it's with you. Yeah.
Yes.
Yeah. Okay, you know. At 11. Yes. Okay, so now you have a little bit longer break. 45 minutes. I hope that you will see.